Hi, I want to talk about the statutory provisions in Ontario dealing with termination pay and other remedies. And this will apply in part to other statutes across Canada. Ontario is different for many reasons, basically because it contains termination and severance pay up to 34 weeks in total, which is different from the other jurisdictions. It also requires the continuity of benefits through the first up to 8 week period. And also, there's a different definition of just cause that I'll just cover momentarily. So let's just go through some of the bigger issues. In Ontario, you should never file a complaint for termination or severance pay if you intend to take a wrongful dismissal action. Once you file a complaint with the ministry, you're not allowed to sue civilly for wrongful dismissal. So be very, very aware of that before you make that filing. A lot of clients will do that independently without seeking legal advice. They don't have a clue what they're doing. You can withdraw it within 14 days, but that has to be done within 14 days. So make sure you don't file a complaint if you intend to pursue a wrongful dismissal remedy. The next issue is that under the Ontario statute, because it encompasses such a long time period potentially, that is 8 weeks, basically a week a year, not quite, but sort of a week a year up to 8 weeks, and then 1 week a year up to 26 if you're over 5 years employment history and the employer has a payroll of 2.5 million or more. Those payments in Ontario are due without any kind of mitigation or other income set off. So in Ontario, if you're terminated and you satisfy those requirements, you're entitled to 34 weeks pay automatically in a lump sum payment, and also continuity of benefits for up to the first 8 weeks. The benefits are important because some benefits are not privately insurable. For example, disability benefits you cannot buy privately once you're terminated. So if you're sick and have a medical problem, the continuity of disability is very important. Again, keeping in mind that the disability claim arises when you become ill. And if that continues, you still have a claim. So if you became ill in the first 8 weeks and you have benefit continuities as described, then you're entitled to termination disability benefits to the extent of the disability period, which could go until age 65. So that's very important. Also, under the Ontario statute, there's a different definition of just cause. Just cause under the Ontario statute requires basically being bad on purpose. The actual word is willful misconduct or willful disobedience, willful neglect of duty. That's not trivial. So it's very hard for the employer to avoid the payments under the Employment Standards Act. It's a higher degree of just cause, which the employer has to show. The other issue under the Employment Standards Act is that if the employer violates any of these provisions, if the employer doesn't pay the proper amount of termination pay that you're owed, or other sections of the Act, if the employer doesn't pay wages you owe, then there's more relief available if you have the right to sue civilly. You can make claims for aggravated damages, unfair conduct at the time of termination causing emotional distress, and or punitive damages designed to punish the employer for acting in a reprehensible or vindictive manner. Some of those claims have been considerable. So the point of all this is you got to know what you're doing. I say don't file a complaint unless you're really, really sure that's all you want under the Ontario Employment Standards Act. And be aware of your rights, be aware of other claims you can make beyond the face wording of the statute if there's a violation of your rights. So be knowledgeable, be smart, and good luck.